Good afternoon and welcome to the Ninth Circuit. I don't see Judge Smith. Shouldn't I be seeing him?
Coming soon. There we go.
Oh, okay. Judge Smith is appearing virtually, unexpectedly, and Mr. Shoemate will be arguing virtually, so we're partly virtual and partly not. In recognition of the many issues in this case, we've put 20 minutes rather than 15 minutes on the clock, and we're not going to be too tight about that either. So I will stop you after a while, but not necessarily precipitously. We will begin with Mr. Shoemate arguing for the Acting Attorney General.
Thank you, Your Honors. May it please the Court, Brett Shoemate on behalf of the United States. For almost 30 years.
Shoemate, I know lawyers hate it when the judges interrupt it when they're just ready to give their big spiel, but in this morning's, I don't know whether you would get this in Washington, but it's called the Los Angeles Daily Journal. And in the on the first page, this judge threatens renewed oversight in Flores immigrant child case. Talks about what Judge Dolly G., who is the presiding district judge of this case, had to say. And if I may paraphrase her, she's sick and tired, after, in her case, 11 years, some before, where the government has simply ignored the settlement agreement. As a judge, when I look at it, basically the government has come up with a lot of different reasons why it doesn't want to follow the settlement agreement. It doesn't think it has to. It's not meaningful. Can you just give me a straight out answer? Is it the position of the current administration that it's not going to follow whatever we say about the settlement agreement? It's going to go ahead and do what it wants. Is that a fair statement?
That is, no, Your Honor, that is not a fair statement. Our position in this case is that the Flores consent decree is a binding court order, but it should be terminated. And we've made a number of key arguments in this case why we think it's time for this important aspect of federal immigration policy to finally be returned to the executive branch. There are many reasons we've explained why the Flores consent decree should be terminated, but if I may, I'd like to focus on just three today in my time here. First, there is no underlying violation of federal law. Second, there is no end in sight. And third, there is no jurisdiction. And the first fatal flaw in the FSA is the absence of...
When you say there's no underlying violation, you're saying that none was adjudicated, or that we should go back to the beginning as of the time that the agreement was entered into and decide whether there was a violation of federal law, or we should decide, which is what I think, and I think Horn directly precludes that. So the question should be whether there's now a violation of federal law. What exactly is your argument?
So our argument is that there is not currently, any underlying violation of federal law, and therefore the agreement must be terminated.
So
Horn says...
You're looking at now. Not
correct,
then,
but there hasn't
now.
been any violation. Excuse me. The Supreme Court upheld the INS regulations in 1993.
Well, with respect to a very narrow issue, that is whether there was a constitutional right to be for children to be released to their people other than their parents. That was it. They said that it wouldn't. They weren't saying that if it was punitive, or if they weren't saying that if it was. If the condition didn't address the conditions, they assumed that the conditions were non-detrimental to the children. So it was a very narrow ruling. Is that wrong?
No, it was a narrow ruling on the issues before the court, which were whether there were any substantive or procedural due process violations. But the key point is that the government won this case already in 1993. The key underlying claim was a ruling in favor of the United States. And yet, 4 years later, the government settled this case, and the Flores consent decree is an agreement that goes well above the constitutional floor.
Which it's entitled to do as a consent decree.
Which it was, well, we dispute that. But setting that aside, the key
Well, there are many
aspect
Supreme
of
Court cases that say that.
Well, we dispute whether this was a valid and legal consent decree at the time it was entered, but setting that aside, the plaintiffs have litigated this case for the last 30 years on the premise that the government has not been living up to its obligations under the Flores consent decree, and that's how they litigated this case below before Judge G. But the key question under Horn is whether there is an ongoing violation of federal law, and if the government has adopted durable remedies. The Supreme Court has said continued enforcement of the order is not only unnecessary or improper, and that's the thrust of our argument in the briefing and today, is that there is no ongoing violation of federal law. There are durable remedies in place. The best example of this, I think,
And forgive me, counsel, and you believe that there's no violation of federal law, but what you are doing is based upon the settlement agreement?
Well, the plaintiffs have certainly alleged violations of the settlement agreement. We have various appeals appealing those findings, but
forgive me, but perhaps I was not being clear. I think I heard you say that you are complying with federal law. You're certainly not violating it, but it sounds like what you are complying with is also, in your view, in compliance with the settlement agreement. Is that right?
Well, the government is making its best efforts to comply with the settlement agreement. We dispute allegations that the plaintiffs have made, and the district court has found certain violations of the Flores consent decree. But that's neither here nor there. In this case, what Horn directs the court to consider is whether there is an underlying violation of federal law, and there is not. And DHS has implemented regulations in 2019 that provide durable remedies. Those, as you know, those regulations have not been allowed to take effect, not because they're contrary to law under the APA, but because they failed to implement the FSA. What we're asking for is for the court to allow those regulations to take effect and for the settlement agreement to no longer micromanage in a key aspect of federal immigration policy at the border. But without an underlying violation of federal law, there's no basis for the FSA to continue.
First of all, Horn was not a consent decree, right? It was an adjudicated injunction. A consent decree is necessarily, or in this instance, entered before there is a determination as to precisely what the violation of federal law is. Do you believe, do you think you have proven that there is no violation of federal law, or that you should have a chance to prove it? And also, do you think that the question is whether there's a violation of the Constitution, or that there is a substantial, as the Seventh Circuit said in one case, there's a substantial likelihood that there's a violation of federal law? What exactly is the issue?
Pardon my interruption.
So I have two questions.
Okay. We have proven that there is no underlying violation of federal law because we won this case in the Supreme Court in 1993.
Oh, I'm sorry, but what you won in the Supreme Court, as I said, was an extremely narrow issue, and it had nothing to do, for example, with conditions of detention, which are an enormous dispute, both before and after the determination that led to this appeal. For the last 10 or 12 years. So, and also as I said before, is that your basic position, that the Reno case governs this and that therefore there's no violation? Is that your argument?
That is one of the arguments. The next argument I would make, Your Honor, is that the plaintiffs have not proven any other violation of federal law.
But you're the one who has to prove a basis for dissolving the injunction.
But we have carried our burden, Your Honor, to identify durable remedies that prevent future constitutional violations. And we've identified a number: statutes, regulations, informal policies that all govern and protect children at the border. Those are durable remedies that haven't been allowed to take effect.
As because to the unaccompanied minors and the HHS behavior, that's largely true. It's not 100% true. We can talk about the 2 or 3 little pieces that were left out, but it's been dissolved with regard to that group and that agency 90%. So we're really talking about DHS which means that we're talking, as I understand it, about detentions at the border, how long and in what conditions children are being held, and then primarily about accompanied minors. And I understand that the government has never liked our ruling about accompanied minors, but it's not only, it's precedent. It's not, you treat it as law of the case, but it's not only law of the case. It is a precedential opinion of this court, which we are bound by unless and until overturned on bank. So given that, the accompanied minor issue, the accompanied minor issue, which is really what the thrust of your complaint is about, is really at core not arguable here and now.
Well, I understand the point, Your Honor, that this court has already decided that the FSA extends to accompanied minors. We're not trying to relitigate that. Yes, we disagree with that, but that's not the point of this argument today. The point of this argument today is to argue about the changes in law or in fact since this court last ruled in 2020, but certainly since the Flores consent decree was agreed to in 1997, there have been enormous changes in not only migration patterns, but in immigration law and the policies that DHS has enacted.
Again, our prior, I mean, one thing we could do is just go through all of the prior decisions in these. There were 5 prior appellate decisions in this case. And most of what you are identifying as changes were litigated in one or more of those 5 cases, including the higher number of migrant families and the higher number of unaccompanied minors and the TVPRA and the HSA and several other things, which I can't remember now, were all in the earlier cases when we were dealt with. So what's new?
So what's new?
First, meaning new since those 5 cases.
What's new? So first of all, going back to last year, we have the One Big Beautiful Bill provision, section 9003, subsection B, that expressly authorizes DHS to detain alien children through family residential centers.
What it did was provide for building them. It doesn't say anything about determining conditions in which they are to be held, and this nothing in the agreement precludes having family detention centers. It requires that children be released from them under certain conditions, and it requires that they meet certain standards. And even as to those standards, I mean, another thing that's been litigated several times is that if you do seem to have a problem with the licensing of those facilities. And you could make a motion to modify the agreement to set up an alternative system to supervise them, but you've never done that.
Well, here, Hunter, that so much has changed since 1997 in immigration policy and the law and the facts. And even since this court last heard this case in 2020, there have been a substantial increase in migration at the border.
And there's also been a substantial decrease.
Well, but just think of this. The emergency that the parties considered in the 1997 decree was 130 minors in detention. In 2023 and 2024, there were hundreds of thousands of minors crossing the border as either UACs or as accompanied, as part of accompanied families.
One thing I couldn't tell about those numbers, by the way, and maybe you know, they're called encounters. That doesn't mean, I don't know quite what that means, but it doesn't mean that anywhere near that number of children or families were detained.
Well,
I think could be detained.
I think, well, they're not allowed to be detained for any period of time beyond what the FSA requires. But it's indisputable that there has been a surge in migration across the border that is far beyond what the parties contemplated in 1997.
But we've litigated that already, right?
But there have been substantial changes even since the 2020 decision. There have been changes in statutes and regulations. Horn says the court is supposed to take a flexible approach to institutional...
Let me ask you this. Let's assume for a moment that you were sitting in my chair or one of my colleagues' chairs, and the government came before you and wanted to change the approach that we're taking now, what opinion would you write? What would you rely upon? Are you talking about vacature? You're talking about the APA? What is your strongest position that the government's desired outcome should be as you would like? And on what basis would you statute it?
Well, thanks for the question, Your Honor. I think the way I would write an opinion if I were in your shoes without disturbing all the prior precedents would be to focus on Horn, the flexible standard that Horn identifies, and focus on the changes in law and facts.
Horn was decided before all of the other cases in this court. And
In
we discussed
2009.
Horn, and we recognized Horn.
That's correct. And Horn also applies to this Rule 60B motion, which is different than the last 60B motion that we filed.
And how's it different?
It's different because in 2019, we were arguing that the 2019 regulations from DHS should be allowed to take effect. But if not, the decree should be modified to allow it to take effect. Now,
well, actually, the problem was that you didn't do that, actually. We said in our opinion, if you do that, it should be taken, you should have the opportunity to terminate it in part, but you didn't do that.
Yeah. I think what I would say in the opinion is that the plaintiffs have gotten more than they bargained for in 1997, which was a 5-year consent decree that was then extended indefinitely. And that raises serious separation of powers.
Well, it wasn't extended indefinitely. It was extended until certain regulations compliant with the agreement were enacted. And you've had, even since 2020, you could have tried again, but you didn't.
Well, it's clear to us that nothing will ever satisfy the district court, and unless it completely matches.
Well, when you came back to us, we changed a fair amount of what she had done in 2020. So we're sitting here. I think we're fairly, fair and even-handed. You can give it a shot, but you haven't.
Well,
we actually did disagree with her a fair amount as in 2020.
I appreciate that, Your Honor, and I'm hoping you disagree with her a lot today and agree with the government that enough is enough judicial micromanagement of this key aspect of federal immigration policy, and to allow this important policy to be returned to the executive branch. If I may, I think a second fatal flaw in this consent decree is its indefinite duration. We're going on 30 years at this point. That indefinite duration, I know it's true. It's linked to the regulations, but we tried that. No regulation is ever going to be sufficient to satisfy the district court unless it perfectly matches.
I just responded on that. Okay, it doesn't have to only deal with her; you have to deal with us.
I appreciate that. I think Horn recognizes that these type of decrees, especially.
I'm not, and I don't want to appear to be accepting your characterization of Judge G. I'm just saying, whatever you think of Judge G, we're here now.
I appreciate that, Your Honor, and that's why we asked the court to recognize there are significant separation of powers concerns with judicial micromanagement of a key aspect of immigration policy that needs to be returned to the policymakers, and federal judges should not be the ones enforcing that outdated policy preference on pain of contempt. As I said,
what you're basically saying, counsel, if I understand it, is it's time for the federal courts to get out of the way. Let's just decide it ourselves. Who are the parties, the litigating parties, then, and where are their fights resolved, if you will, if the courts are not involved?
Well, I'm not, Your Honor. It's a good question, but I'm not saying that the courts will not be involved, because what will happen is, if you terminate the consent decree, the regulations will be allowed to take effect. And if these plaintiffs here today in court have concerns about DHS's compliance with those regulations are judicially enforceable. But the key thing that we're asking for,
with regard to the accompanied children, the regulations have no supervision over the conditions or the licensing of the family centers. They have no bond hearings for those children, or any way to release those children, as I understand it. Those children are going to be in, and then we have a record in the district court even as of August, of substantial problems, serious problems in some of these family centers in terms of the impact on the children, their lack of education, and so on and so on. And then, I mean, your strongest argument, to be fair, to give you some advice, is that maybe we should be getting a more complete record with regard to the current conditions in order to determine, I would say, not necessarily whether there is a constitutional violation, but whether there is a substantial basis to think there's a constitutional violation now. That's
respectfully
a viable argument. So
that is not the argument we're making, and we are not asking the court for a remand. We're asking the court to give us a thumbs up or thumbs down in this court, whether the Flores consent decree should be terminated. And I take your point, Your Honor. There are policy disagreements with the 2019 regulations. But this court's opinion in 2020 said the regulations can't take effect, not because they're contrary to law, but because they don't implement the FSA. If the FSA goes away, the plaintiffs in this court can raise new claims, either constitutional claims or seek to judicially enforce the regulations themselves. Your Honor, I see my time is up. If the court has any questions.
When you think about this, how without the involvement of Judge G can we determine whether there is, in quotes, a durable remedy, in quotes?
Your Honor, I don't think you can take anything away from, draw any inference from Judge G's orders enforcing the FSA about the ultimate question under Horn about whether there's an ongoing violation of federal law. She hasn't made that finding, and that's because the plaintiffs have not litigated this case on the basis that DHS is not complying with the law. They're litigating the case on the basis that the government hasn't complied with the FSA. So what we're asking for is that DHS's compliance with the law be evaluated and assessed based on the law, not a 30-year-old settlement agreement.
Let me ask you this. There has, of course, been a lot of fighting in Congress about the FHA and all these various kinds of things. Are the issues we're talking about here even being considered in terms of finances?
Your Honor, I don't know if these issues are part of the discussions in the reconciliation bill in Congress. I do know that in 2025, last year, Congress legislated on these issues in the One Big Beautiful Bill provision we were discussing earlier, and also the Lake and Riley Act, both of which I think reflect the view of Congress. What did the Lake and
Riley Act do? All it did, as I understand it, is add a couple of additional circumstances in which there is mandatory detention.
It also creates a cause of action for states to sue DHS for injunctive relief if they release an alien and that alien causes harm within the state.
What does that have to do with anything? First of all, is there anything in the record to just suggest that any of the children who were ever released, given the fact that the agreement provides for children who were convicted of various crimes to be kept in secure facilities, but any child who was released has ever committed a crime that hurt anybody? I mean, maybe they have, probably they have, but is there anything in the record to show that?
I'm not aware, but the point I'm making is that those two statutes, I think, reflect a longstanding congressional preference for detention of aliens at the border, starting with sections 1225, 26, 1231, statutes that are enjoined from taking effect.
These are children. They didn't come of their own accord, for the most part. I mean, some of them are the unaccompanied, but mainly at this point, we're not talking about the unaccompanied children. We're talking about the accompanied children, and 2-year-olds, babies.
Right, and there's nothing in the statutes that carve an exception out for accompanied children. This is a policy preference that we agreed to 30 years ago, but it is not reflected in any congressional policy. It's not reflected in DHS's policies, and I think this gets to the fundamental problem: is that federal judges.
So the problem is that you fundamentally disagree with what was agreed to.
Yes.
You even fundamentally disagree that it was agreed to.
Absolutely. That's why we're here. We're seeking termination of the decree. Yes.
Yeah. Let me ask you this. The district judge asks that things be put into the Federal Register, and the government doesn't seem to want to do that. What's the argument as to why you should not be required to put things in the Federal Register as the district judge wants you to do?
Well, thank you, Your Honor. The government did with respect to the HHS foundational rule and the 2019 regulations. I think what you might be referring to is the HHS interpretive rules that interpret the foundational rule, which the district court said in this particular case were not sufficient to completely release HHS from the FSA. But the interpretive rules are valid methods for an agency to conduct rulemaking, and they clarify the way in which HHS.
First of all, I mean, some of them, one of them might be fairly said to be interpretive. The other two seem to conflict with the so-called foundational rule rather than to interpret it.
Well, Your Honor, we disagree with that. But the ultimate question, again, is whether there are durable remedies to protect children at the border and prevent ongoing constitutional harms. That's the ultimate question that I would ask the court to focus on.
Let me ask you this. Does the government contest the notion that if children are being held in conditions in which they can... One, there are people who are outside the facility who are willing to take them, let's say their grandmother, but they can't get released. And two, they are being kept in conditions which at least some of the evidence seems to suggest, and some of the evidence that could be put in the record further suggests that where they have light, they can't sleep, they don't get decent food, they don't get decent medical care, they get school one time a day, if at all, and all they do is color. They're supposed to be in non-secure facilities, but in fact they can't leave the building. There's very little space for any kind of outdoor recreation at all. You think you think that's not happening, or you think there's no constitutional problem if it's happening?
So first of all, I would say the DHS and HHS have regulations that address the treatment of minors at the border. Second, to the extent these plaintiffs contend or
DHS
believe...
have any regulations that address all of those circumstances? Does DHS have any regulations that accompany children have to have some sort of hearing now to see whether they should be released to people outside these really quite restrictive and detention facilities? Is there any regulation that requires that?
No, I think this goes back to the court's 2020 opinion. That was one of the deviations between the FSA and the 2019 regulations.
All right. So is your position that it is not a constitutional problem to keep children? And also, I mean, one of the things that the Reno opinion said is that you can't be punitive. Deterrence is part of punitive. You've said that a lot of the reason you're doing this is to discourage families from coming in the first place. So you're basically punishing children because their parents brought them there, and they're going to be in these very destructive facilities. You're saying there's no constitutional problem there, or what?
Your Honor, I understand that the detention of children at the borders is a controversial policy issue, but that's a policy decision that needs to be made by policy.
You're saying there's no possible constitutional problem. However you keep the children, whether you let them out or not, and whatever conditions you keep them in, there's not a constitutional problem. Is that what you're saying?
I'm not saying that. I'm saying the plaintiffs have not alleged or brought that type of claim here. They've litigated this case for 30 years on the premise of the FSA.
That's what they've been trying to do, to get the statute, to get the agreement enforced by demonstrating that these things are happening, even though the agreement says they can't, and that the agreement wasn't based on a finding of constitutional violations, because that's not what you do in a consent decree. But it was at least based on allegations of it, and if those are at least colorable allegations, why isn't that good enough?
But the FSA goes well beyond and well above the constitutional floor.
Well, of course, and we have many opinions, Horn included, that say that that's what consent agreements can do. But
again, I bring it back to Horn. The key test that the court has to apply is whether there's an underlying violation of federal law. And there is not in this case. The question is whether
your position is that if things are as I described them, that's not a constitutional violation.
Well, that's a hypothetical, Your Honor, that if those facts do exist, the plaintiffs can bring a new claim, bring in new lawsuits, maybe somewhere in Texas, maybe in New Mexico. But we shouldn't have a single federal judge dictating the policy with regard to a class of hundreds of thousands, and if not millions of aliens at the border on the basis of a 30-year-old consent decree in light of all the changes that have happened in the last 30 years.
Okay, well, your time is well up, and we'll give you a couple minutes in rebuttal. Thank you very much.
Thank you, Your Honor.
It's good to see there's somebody still in DOJ.
Good afternoon. Carlos Holguin on behalf of plaintiffs. May it please the court. As many times as I've read Rule 60 of the Federal Rules of Civil Procedure, I've never seen it say that a consent decree can be undone because enough is enough. We have been trying for many, many years now to improve in fact, as opposed to just aspirationally, the treatment of children in immigration-related custody. It has been a labor of Sisyphus in many ways, as has the plaintiff's obligation to respond to continuing motions to modify, motions to terminate under Rule 60 that have been brought in the district court and have been reviewed in this court. The truth of the matter
is the rock that Sisyphus rolled up the hill a uranium agent made?
No. I think that there are certain things, Your Honor, that we may change pursuant to policies and so forth, but there are other matters that are simply bedrock. One is that we should not mistreat children. We should treat them in accordance with the standards of international law and what the Constitution requires. That is not something that is a policy choice. That is something that is constitutionally guaranteed and is respected around the world by countries that are much less solicitous of individual rights and liberties than is ours. Now, as far as counsel's argument that we are required to prove a continuing violation of federal law every time we seek to enforce the settlement, I would say no. It is the government's obligation to show that there is no violation of federal law and that it's, in fact, following the regulations and standards that it posits, which, in my view, at this point in time, have been proven more aspirational than real.
Well, all right, but we do have Horn, and Horn is, I was on the author of the opinion that got overturned in Horn. It does seem to say that the measure, at least as to litigated injunctions, one question is, are consent decrees different?
Yes.
That the question under 60b-5 is not whether there was compliance with the agreement or with the injunction in that instance, but whether there is, they say, a ongoing violation of federal law, as to which there is no durable remedy. Now, so why would you say either that those standards don't apply or they're met here?
Well, Your Honor, I think that if, on the one hand,
or third, that we should remand to get more determination by the district court of some standard as to what the actual on-the-ground conditions are now.
I think, Your Honor, it's difficult. There's, on the one hand, as you point out, there is this statement in Horn. On the other hand, that was not a consent decree. It was a litigated injunction. There were also federalism questions.
Although they do talk about consent decrees a lot.
Yes.
Somewhat derogatorily, as being worse.
Yes. But the point is that if the federal judiciary is going to encourage settlements, a litigant cannot or should not be required to come in at the opposing party's request ad infinitum, simply and be required to show over and over again that there are continuing violations of some federal law, separate and apart from the consent decree itself.
But the Horn seems to suggest that there is maybe some requirement. I would suggest that the real difference between the consent decree and a litigated decree is that you shouldn't have to prove that there actually is a violation because you never proved that in the first place, but that there is arguably or substantially likelihood or something like that of a constitutional violation, at least once. I don't think you've ever actually, I mean, you've had all these enforcement proceedings, but they've always been as against the decree as opposed to as against some constitutional standard.
That's correct, Your Honor. But I think the difference here is that the evidence that is presently before the district court definitely suggests the presence of constitutional violations.
Well, presently when? Presently in August of 2025 or presently now?
Both.
And maybe more so now?
Counsel, you probably were at the beginning when I showed a copy of the Daily Journal article today about what Judge G had said. Her frustration with the long, from her perspective, spinning on both sides. She thinks that a trustee may need to be appointed to ferret out the facts so that people can make the allegations necessary to do one thing or another. What's your response to, at least the way I've interpreted, what Judge G has said?
Well, I think that that's correct, Your Honor. The district court is in a difficult position. It has found substantial evidence that the government is violating both a settlement and I think the logical extension of what the court has found, the Constitution as well. The only way that the court has to sort that out, at least at present, is by the appointment of a special master or independent monitor, which the court has indicated it's seriously considering doing. There has been a special monitor appointed in the past whose term is expired and whose reports have informed the court's views as to whether the government is complying with the settlement or not.
I thought she basically relied on the internal people.
There are internal people, the juvenile coordinators, as well as an independent monitor.
And she did have an independent monitor at some point?
Yes, Your Honor.
Right.
So from your perspective, sending this back to the district court is perhaps even essential.
Yes, Your Honor. Absolutely.
Sending it back for what?
For fact-finding as to whether there is a substantial question of violation of independent federal laws, the Seventh Circuit recently articulated, or whether there is a substantial violation or whether there is an existing violation of the Constitution that the government continues to perpetrate on children as a result of the conditions that we have documented. But in either case—
What do you think the impact of the Reno case is on that question?
Reno held that as long as the conditions of confinement meet the standards of license placement, and not only aspirationally but also in fact, that then it is appropriate for the federal government to deny release to unrelated adults. That is the essence of the Reno decision. When that decision came back down, the Supreme Court didn't instruct the district court or this court to dismiss with prejudice or anything like that. It came down for a trial on whether the government was actually meeting the requirements of a memorandum of understanding, which required this licensing and other improvements and conditions. The government decided it didn't want to litigate that. It would rather settle. And here we are today based upon the government's decision. But this is a settlement. Parties settle cases all the time because they have various motives and so forth, but we cannot, and I don't think we should, be disturbing settlements because one party decides that it's no longer convenient or enough is enough or any of the other reasons we have.
Or that it shouldn't, I mean, what they're really saying is one administration shouldn't be bound by what another administration did. That's what they're saying.
Yes, and no party would settle for longer than a current administration's term if that were to be the case all the time. Now, Rule 60B allows a party to come back in if the subsequent administration disagrees with whatever the prior administration agreed to, and under certain circumstances, showing changed circumstances, they're entitled to get the consent decree or the settlement modified or even terminated. But the government has failed to meet its burden in this case. It's failed to do any of these things. Rather, it's come to this court once again and talked about the 2019 regulations, which this court carefully considered and said were insufficient to sunset the settlement. Now,
But in fact, the agreement has been sunsetted
Yes.
with regard to most of the HSS.
Exactly. And that only shows the court that the government is able to comply with the terms of the Flores settlement and terminate the settlement as the parties agreed in accordance with the procedures the parties agreed by voluntarily entering into a contract. There's no reason why they cannot do this with the 2019 regulations on the DHS side, and there's no reason why HHS cannot clean up the rest of its conflicts with the settlement by enacting regulations that actually resolve those conflicts as opposed to trying to sweep them under the rug. There are only three things here that are new, right? One is the big, beautiful budget bill, which, as Your Honors pointed out, is really just a funding mechanism. Two is the Lake and Riley Act, which only adds a couple of criminal categories to the prior law and does not target children specifically in any event. And three is Alamin Gonzalez, which talks about 8 U.S.C. 1252 F1 and some restrictions on jurisdiction.
Is Alamin Gonzalez new? I mean, how does it get into to 60 B5?
We don't think it does, Your Honor. The government has seized on these three items, in our view, in plaintiff's view, as pretext for taking another run at this court, taking another run at the district court, and essentially asking for a do-over. Again, I refer back to my labor of Sisyphus, in that we have already addressed the validity of the 2019 regulations, whether 1252 F1 even applies, the interference with the Administrative Procedure Act. All of these things have been litigated or certainly could have been litigated before this court before now.
Well, those two particular things were not litigated earlier, before this court. Is that right?
I believe they were, yes.
They were? Where?
Well, if you look at the main
most of the
one
rest was litigated here, but those two things I'm not sure they were.
Which was? I'm sorry?
Most of the rest of what's being raised was litigated before, but I didn't think those two things were litigated.
Well, I would refer the court to Rosen in 2020, and in that case, in the government's opening brief, they argued that the government is fulfilling its. Government was arguing that it should be able to we would have to relitigate the issues around underlying federal violations. That was certainly raised. In the 2019 regulations and the proceedings before this court, it was certainly an argument the government could have raised that the APA was being unlawfully interfered with.
I know that. I'm just asking what they did, what we decided.
Well, I
didn't think we've ever decided anything about 1252F or the APA.
Well, actually, yes, that was done very early on. In Rosen, the government argued that this court is entirely inconsistent with fundamental APA rulemaking to have a contractual agreement preordain any specific outcome. That's in their reply brief at page 27.
Presumably not addressed because it was in this reply brief.
Well, the idea that there's an APA violation here was certainly something that could have been argued and actually was referenced in the government's prior briefing. The HHS foundational rule in any event shows that the government may comply with the rulemaking provision of the Flores settlement without running afoul of the APA. And it did so successfully. If anything, the public comments that were submitted in response to the foundational rule urged the government to be more solicitous of children's rights than the foundational rule provided. I would also point out that when the government entered into the Flores settlement agreement, they represented that and warned that they were further fully authorized and empowered to enter into the agreement. Again, this is something that can be waived. I would say that if, at the very, very minimum, this court should be concerned about the voluminous evidence before it showing substandard conditions in
You say
detention.
evidence before us. Are you talking about some of the evidence that you wanted to introduce in this court that has not yet been given to the district court?
The evidence is that we've presented to this court in a request for judicial notice has been presented to the district court.
But not at the time of this order.
Not at the time of this order, but there was plenty of evidence before the court.
It is true that Judge G, in discussing the durable remedy issue and in determining the termination question, it seems like she didn't do exactly what Horn says, if Horn applies, or even as modified as you've suggested and as I've indicated may be right, to have a substantial piece. But she didn't do that. She looked only at the agreement, both with regard to the existing violation and with regard to or even the arguable existing violation, and with regard to the durable remedy. Is that fair to say that that's how she was looking at it? It's not odd that that's how she was looking at it, because you might think that that's what you do with a consent decree, but it's not what Horn said.
I think Horn had been raised before in this court and in the district court several times. I think what Judge G was attempting to do was to faithfully follow what this court had said on numerous occasions before then. Mm-hmm. If there is a change of heart, if there is a change in what the court believes Horn requires at this point, then the only real fair way to deal with it is to remand the case for further factual finding with instructions as to what the district court is supposed to do.
And there is already a lot of material in the record. Later material in the record, as well as earlier material in the record.
But this,
I understood you to answer Judge Smith earlier to say, yes, that's what we should do.
Yes. And I think it bears emphasis that under Rule 60, it is the government's burden to show that it's complying with federal law, that it shows that it's complying with the Constitution, and to show that the consent decree is going beyond what federal law requires in such a way that is burdensome to the government. I don't think it can show any of those things, but we should all have a chance.
Even with regard to what the record, to making a record at this point, really the onus is on the government to come in and show that they are complying.
Yes, Your Honor.
As far as I know, all that's in the record about that is some statement saying, we're doing great, but nothing else.
Yes, that is what the government has said for many, many years now.
But there's nothing specific. Is there anything specific?
I believe they have submitted some evidence showing that there are, according to their records, for example, temperatures in some of the holding cells are adequate. But there is no comprehensive record where the government has come in and shown that children are being properly treated in accordance with constitutional requirements. I don't think they can show that.
One technical question. Am I correct in understanding that the DHS regs cover the family or the accompanied minors, but also the border facilities?
That's right.
That apply to unaccompanied minors? All minors?
Yes, because there is a period of...
Because there's a few days or something.
Few days, okay. Correct. But those days have distended, shall I say, for many, many days, again, in violation of their own standards and in violation of the TVPRA and in violation of the Flores settlement. So we are in this continual process of trying to ensure that the government lives up to its side of the bargain, lives up to what the federal law requires. And, one day maybe.
Does TVPRA apply to the border, to children at the border, or only to children after it doesn't, right? It only applies to them once they've been transferred to HHS custody.
Well, the TVPRA requires the transfer to HHS
right, but
custody.
it doesn't apply to the conditions before that.
Conditions, no.
Okay.
No. With the last minute that I have, Someone once wrote that a measure of civilization's complexity is the distance between the aggrieved individual and the administration of justice. I'm not quite sure what that means, but I do believe that it means that we need to keep in mind the treatment that children receive in this country. There is a minimum there. There's a floor we should all be observing and cognizant of. Without the Flores settlement, I despair that floor would remain with us for very much longer. The entire process, the entire aim of the government in this appeal and in this litigation is to free itself, to do what many declarations in front of this court say they're already doing, and they wish to do it freely. That is not a durable remedy. That is not giving children the benefit of their bargain. Thank you.
Thank you very much. Mr. Shoemate, I can't see you right now, but I guess I will in a minute. Okay.
Thank you, Your Honor. Can you hear me? Can you see me now?
I can see you now.
Okay, thank you. If I may, I just want to address this point about a remand. To be clear, we are not asking for a remand, and the court should not remand this case back to the district court to give the plaintiffs another bite at the apple to try to prove a constitutional claim, which they already failed in the Supreme Court to do. And that's for 4 reasons why you should not remand. Number 1, they waived these arguments about ongoing violations of federal law in the district court below. Instead, they chose to argue that we hadn't carried our burden under Rule 60.
Did you make a factual showing or a legal showing with regard to the question of whether there are in fact ongoing constitutional violations? My reading of the record is that you have a statement, a general statement that the conditions are better than they've ever been, and that's pretty much it.
Well, we have statutes, regulations, and other policies that
No, but on the ground, whether there is in fact either is a constitutional violation or there's a substantial likelihood of a constitutional violation. Have you made any factual showing?
Well, Your Honor, we don't have to prove a negative. It's the plaintiff's burden to prove a constitutional violation.
But you have to prove a reason to terminate the agreement. So you have to, as I understand Horn, you do have to prove that and they did in Horn, according to the majority, demonstrate. Well, actually, what happened there was they remanded so that they could show it. They did not rule on the record there. They decided they laid out some principles, and then they said that the burden was on the government to show it.
Right. We have carried our burden to show that there are durable remedies that far exceed the constitutional floor. If the plaintiffs wanted to argue that those durable remedies are inadequate constitutionally, they could have raised that argument, but they failed to raise that argument, and therefore they waived it. Second, the violations of the Flores consent decree do not equal constitutional violations. They equal violations of the Flores consent decree. But again, the regulations have never been allowed to take effect. And finally, to the extent the plaintiffs have additional evidence that they want to try to prove this constitutional claim, nothing prevents them from filing a new lawsuit, raising a new constitutional claim, and seeking discovery on those claims. But they shouldn't be allowed to continue to benefit from an ongoing 30-year settlement agreement that continues to bind the hands of multiple administrations. The court should terminate the Flores consent decree and allow the plaintiffs to have their day in court if they want to bring a new case. Thank you, Your Honors.
Any questions? All right. Thank you very much.